Hi guys, my name is Teh Tai Yong. So today I will be sharing this video for the purpose of proposing the Malaysian to have our own COVID-19 law. Since the March 18 of 2020, all Malaysians have been staying at home and a lot of us are working from home due to this movement control order, the MCO. So at this moment, all of us are fighting against this coronavirus, or we call it known as COVID. And half of the world population are actually having this movement control. So more than 3 billion population, we are unable to move in and out in certain country. And if you look at the statistics today, the world has actually hit more than 1.4 million confirmed cases of coronavirus, and the death toll is also increased many folds. In Malaysia, we have this MCO on the 18th, and the confirmed cases that time was 790 cases, and today we have more than 4,000 over cases. But relatively, our death rate still remain under control at about 1.5–1.6%. compared to the world average about 5.7%. So this is something that our government is doing quite right in this direction. So the speed of the spreading and also the effect of contracting COVID-19 is nothing we have seen before. Our Prime Minister Muhammad Tan Sri Muhyiddin said on the 27th of March that we are a nation at war with invincible forces. The situation we are now facing is unprecedented in the history. This unprecedented situation, of course, requires unprecedented measures. So today I'm here to actually propose the new COVID-19 law for Malaysia. What is COVID-19 law that I'm talking about? It is a law that provides temporary measures for businesses, especially for the small and medium enterprises, the SMEs, that are adversely affected by the COVID-19 pandemic. So while we are all staying at home and working from home, there are many contractual obligations are still running. So for example, the rental of the business premises is still running because you sign a tenancy agreement between the landlord and the tenant. The salaries of the staff is still running because there's employer and employee contractual relationship. If you sold goods to someone else or services to someone else, you are supposed to deliver the goods or services, but now you are unable to perform. Or the construction industry, you are supposed to build in these few weeks, but the construction just simply could not take place because of the MCO. Loan repayment between you and the banks, and hire purchase agreements between you and also the finance company. So while the government actually have taken the stimulus package that was announced on the 27th of March, as well as on the 6th of April. It is good because there's a subsidies on the salaries and a rental waiver for some government-linked companies if the property is actually owned by the government or the GLC. And also the Bank Negara has actually announced a 6-month moratorium on the loan repayment. These are all very good. However, there are also other contractual relationships that fall outside this few situations that I've just mentioned. So it is expected that after the MCO is lifted, there are many claims under the contracts that either a certain party have actually breached a contract because he or she could not perform the part during the MCO period. So therefore, that it may result in the party having to pay damages, liquidated damages, or some compensation If the person is not able to pay, and this is a real problem now because the whole economy is not in a good shape, and the situation becomes more dire, and you can foresee that bankruptcy and also winding up process are coming in real soon. So this is a situation, the COVID-19 law that we are proposing now is that it will grant the relief for the contractual relationships when we are facing the MCO. Now, next question is, why is COVID-19 law important? Because many businesses, especially the SMEs, are gravely affected by the COVID-19 pandemic. So it is not exaggerating to say that many SMEs are at the brink of collapse because they are running on a cash, out of cash to actually sustain their business, because cash flow is a real problem now. The effects is that, if government don't step in to help this SME, a lot of SME will be closing down real soon. As you know, in Malaysia, 98% of the business establishments are actually the SME, and it has contributed to about 40% of the GDP in this country. And more importantly, the SME actually provides job to about 70% of the Malaysian workforce. So, in other words, SME is the backbone of our economy, and we cannot just see them going down. So it is the duty of the government to step in to help out over and above the wage subsidy, and also the rental, the electricity, and also the deferment of certain statutory payment. I think those are very good measures, and those are really, really helpful. On the other hand, I think there are also other contractual relationships between the SME and other companies that they need to fulfill. So this COVID law actually has been tabled in Singapore, known as the COVID-19 Temporary Measure Bill, that was tabled early April 2020, and it is being debated now. So it will soon become the law, and the term of the law, they term the law as the legal circuit breaker in Singapore. So in a free economy like Singapore, the government is actually very reluctant to actually intervene into the contractual relationship between the businesses. Now, this is because there's a legal concept called legal sanctity of contract, where parties are free to negotiate and agree upon on the terms of the agreement, and therefore enter the agreement, and no other parties nor the government should actually come in and interfere. However, in this pandemic situation, I think the situation is far more worse, and the worse than what we could ever imagine. Some people say that this is like a World War situation. So therefore, I think the Singapore government has actually taken the step to actually legislate the law to help out the businesses by having this law. The next question is, which areas the law should cover? So the legal circuit breaker could cover several situations, several contracts. Number one, construction-related contracts. Now, as we know, the supply of the raw material, the supply of these construction machineries and all these things has been badly affected even before the MCO, because a lot of countries have actually closed their borders. So, for example, the materials coming in from China, it has been affected before even we have this MCO. The next issue is also the manpower, because manpower issue, a lot of countries have actually closed their border, having this travel restriction. So in and out of the country is getting from bad to worse. So foreign workers are not able to come in because they have either facing the situation where Malaysia do not allow them to come in, or their country actually do not allow them to go out from their home country. So the situation of the construction contracts that they are not able to fulfill these contractual relationship, these obligations during this MCO period, and perhaps for a certain difficult period after the MCO is lifted. I give you one example of this construction contract where the housing developer enters into a contract with the purchaser, and they sign the prescribed contract under the Schedule G or Schedule H out of the Housing Development Act. Under the contract, there is no force majeure clause to say that to cater such a situation of MCO. So basically, the developer has the obligation to deliver the house within the specified time stated in the contract. It's either 24 months or 36 months from the date of the sale or purchase agreement. However, during this period, where a lot of businesses are affected by MCO and also the thereafter effect, if the developer is unable to deliver the vacant possession, the house, to the purchaser, and therefore the developer has to pay liquidated damages at the rate of 10% per annum from the purchase price. Now, it may look very unfair for the developer having to cough up this money, because this MCO is not actually caused by them. It is the world pandemic, and there's another example of a construction contract where the employer should not actually impose a penalty on the contractor just because the contractor could not perform their duty and finish up the construction work due to MCO restriction, right? So this is the first situation. The second situation that the COVID law could cover is on the tenancy and lease agreement especially for the commercial properties. So we can see that a lot of businesses are forced to close. Shopping malls, they are closed. You cannot run, especially for the non-essential services. You are not supposed to open for the business. However, the rentals still continue to run. Now, it is good that the government has this initiative to say that if the property is owned by the government or some of the GLC, then they are giving a waiver to this respect. However, the law should come in to regulate that in the event the company is not able to pay rent, and this has to be genuine during this MCO period and also the affected period thereafter, then the landlord should not actually take a legal action, for example, to terminate the agreement or to evict the tenant out of the property. The tenant should be given some time to actually breathe, to actually recover from this MCO period. Now, of course, when we enact the law, we have to specify that the party have to prove that they are really and in a genuine situation that they are not able to pay the rent. One example is in Germany, when the government actually announced that such a similar measure. There are a few big companies actually opt for this and not to pay the rent, but they found out that these big company actually made 2 billion euro of profit last year, and so therefore they received a lot of criticism. So if the law comes into place, it has to be for the SME who are genuinely affected adversely by COVID-19. The third situation is on the tourism, hospitality, and also event-related companies. Now, we all know that, for example, international conferences, you book 1 year ahead because you need to lock down the hotspot that international delegates fly in from many countries of the world. And for example, wedding banquets, and also you book the hall, the banquet hall 1 year ahead, or some even longer if the hall is actually quite famous, and really people want to actually put their money and book at a particular date. Now, so hotels, event hall, banquets, all this tourism industry, a lot of bookings are made well in advance. So for example, a booking made last year in August, and you're supposed to have a birthday party or wedding reception in the month of April. It's physically not possible to have that event at this moment because we under the MCO, and even after that we are supposed to have the social distancing for a good period after that. So when the law comes into place, then it should state that the deposit or the money paid for making a booking for such an event should not be forfeited by the hotels or the event company. So this is to actually protect the other party, even though such a term is not stated in the contract, because this is actually an unprecedented event that happened. Right, so the party actually can negotiate. Maybe they can postpone the event to the later date. The fourth situation that we can apply this COVID-19 law is on a loan agreement and also hire purchase agreement. In Malaysia, this is largely addressed already by the Bank Negara's announcement on the 6 months moratorium, which is a very good effort and by the Bank Negara. So if we enact the law, then we can actually impose a term, a clause that the banks or the financial institutions are not supposed to take any legal action for a certain period of time, even after the MCO, right? So it should regulate the process, the foreclosure process. It has to come after the time, at least for 6 months. The fifth situation is the legality of the online virtual meeting. Now, during the MCO, a lot of companies and associations are having meetings, the virtual meeting and meeting online. So it has to become the new norm now. So, however, our law has not has to catch up with this new phenomenon where people are meeting online. At this moment, a lot of general meeting, for example, the company's annual general meeting or the association's annual general meeting are conducted face to face, and at certain time, maybe 1 or 2 will die in using the online. So the question now is that can a company or an association's annual general meeting to be conducted totally online? So that is a question. So so perhaps during this period of time, the show has to go on. We can't say that we're not supposed to meet. And in fact, the Malaysians have found several ways, several apps and software to actually meet online. So that is not a problem. The question is the legality for recognizing meeting during this tough time where we are supposed to exercise social distancing. Next is number 6 is legality of witnessing the signing of the legal documents during this time, MCO, and also the affected time thereafter, because a lot of transactions now, because it involves especially those involving transfer and charging the properties, involves the document having to be witnessed by a lawyer in Malaysia. Now, this is especially true when people are seeking for finances. Maybe they go for refinancing after the MCO is lifted, and however, people are quite reluctant to travel, and on the other hand, people are actually advised to have this social distancing. The question is, can a legal document to be witnessed? If I look at you now, I see you signing at this moment. Can a lawyer actually witness a signature? Or do we have to insist on the traditional way of being present in front of you physically, or can it be witnessed using this technology? Now, personally, I feel that even the court proceedings in many countries can be done online using using technology. There's no reason for us to actually to be so rigid that it has to be physically in front of you. Of course, the real concern is whether the document you're signing when you're on video conferencing is the document you receive at the end of the day. But I think that is not a major issue, because that can be done by using verification, some cross-check after you receive the document. That will solve the problem. And having said that, this is not the only way to witness. If you are truly not comfortable, then if you find that there's other, dubious situation where you are not comfortable to witness signature, you can always go for the traditional witnessing face to face. So the legality, it should give an alternative to the parties to actually allow such a situation. Right? I've actually discussed about the background, discussed what is the COVID law all about, and why is it so important for us to enact such a law, and which area to cover. These are several points that we actually can refer to the experience in Singapore. They have actually done the second reading, and it will be soon passed in the Parliament as a piece of law. So to conclude, I think it is the right time, it is a time for Malaysia to have our own legislation to address such a situation for COVID-19, because the impact on businesses is huge, on contractual relationship. Usually countries, the government are quite reluctant to interfere because of the sanctity of contract. However, I think the COVID-19 pandemic is something totally we never expected before. So if you allow this economy to get worse, I think a lot of people will get hit, right? So we hope that with this new legislation coming in, the businesses, especially the SME, they are given a time to actually breathe after this catastrophe that we are facing now, being locked down and during the MCO. So given the right assistance, and I hope the businesses are able to emerge stronger and better in the future. So this would be good. Such a law will be good for the business community, the company itself, for the business community, as well as it is good for our country in the long run. So with that, I hope everybody stays safe and stay strong during this COVID-19 pandemic, and I wish you all the best. Thank you so much for watching.